an adjudication bench trial as it relates to the parents of these children. May I have the names of our participants, please? And then we'll get to, well, one child, and then we'll get to the bits of a sidebar that are going to direct, I think, this afternoon's proceedings.
Can I ask if we're going to be on YouTube?
We are.
Thank you.
Okay. Appearances, please.
Katerina Dumont, lawyer guardian ad litem.
Ms. Saja Thomas, counsel for the department. Your Honor, Ms. Jamie Freeze is the CPS worker. She's very sick today. I told her that her presence would likely not be necessary. So she is on standby if the court needs her, but I just wanted to inform the court of that absence. And also present is Ms. Brandy De La Garza, and she is the current foster care worker.
Thank you.
Michael McFarland. Oh, sorry, I'll let them introduce themselves.
Brandy De La Garza from Fostering Solutions, the foster care worker.
Michael McFarland, representing mother. Please introduce yourself.
Victoria Dior.
You need to get a little closer to the microphone. You were breaking up.
Victoria Dehart.
Much better. Thank you.
What's the last name? Needle.
Dehart, I believe. D-E-H-A-R-T. Is that right, Miss Victoria?
Yes, Your Honor. Okay, got it. Thank you.
All right. Mr. McFarland, would you like to make some comments about the sidebar?
Yes, Your Honor. Obviously, my client is in jail, unable right now to parent for her child. She is in jail based upon the same concerns that are in the petition, which are number 8, 9, and 10. Therefore, we would be requesting to enter into a no contest plea. I've discussed with my client. She does not need the petition reread. At this point in time, she's done some classes in jail, like a family team meeting to discuss what the case service plan would look like. We realized that there'd be a psychological evaluation, a drug evaluation, parenting classes, also help with housing, I should say, transportation. These are some of the numerous concerns that we think would be addressed in the case service plan.
All right. Any objections, Ms. Thomas?
No, Your Honor.
I should also add that we talked about waiving the workers testifying and relying upon the petition itself, which I have no objection to.
Good. I understand that that did come from you originally, Ms. Thomas. Is that right?
Yes, Your Honor. That was in hopes that Ms. Freeze would not have to log in and testify.
All right, Ms. Dumont, do you find the plan for the no contest plea to serve the best interest of the minor child in this case?
Yes, Your Honor.
Any thoughts on using the contents of the petition in lieu of the testimony of the worker?
I would stipulate to that for the factual basis as well.
Very well. All right, Deputy Ames, would you swear in Ms. Victoria Dehart, please? All right, Ms. Dehart, have you been able to look over a copy of the petition dated September 20th, 2024?
Yes, I have, ma'am.
Very good. You had a chance to talk to Mr. McFarland about that?
Yes.
All right.
Before this in the breakout room.
Okay, good. So he's put on the record that you'd like to enter a no contest plea, meaning that you wouldn't admit necessarily immediately to me what's been happening in the petition, but rather that I would consider what's in the petition to be accurate completely. In other words, if I accept your no contest plea, I'm accepting effectively what's in the petition in its entirety. Do you understand that?
Yes, ma'am.
Very well. And there would be a case services plan built around that, which Mr. McFarland has already talked about some of the things that would be asked of you to accomplish. Did you hear all that?
Yes, Your Honor.
All right. All right. If I accept your plea, you're giving up your right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses appear against you and testify under oath at trial. The right to cross-examine those witnesses. And the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you enter a no contest plea?
Yes, Your Honor.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court place him with mother or father or with relatives or in a foster home in order programs for you and your child, such as counseling, drug and alcohol treatment assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. DeHart?
Yes, Your Honor.
Do you have any questions about any of the information I've given you so far?
No, Your Honor.
Is anyone making you enter a no contest plea?
No, Your Honor.
Has anyone threatened you in order to get you to enter a no contest plea?
No, Your Honor.
Has anyone promised you anything in order to get you to enter a no contest plea?
No, Your Honor.
Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this afternoon?
No, Your Honor.
Very good. Would you say your decision to enter a no contest plea is one you've made of your own free will?
Yes. Yes, Your Honor.
All right. All right. As I look at the petition, for purposes of the factual basis of the plea, obviously you were coming to us from Lenawee County Jail.
Yep.
At this time, is that right?
Yes, Your Honor. It is.
Thank you. All right. It would appear that there are some criminal charges, and as a result of that, for example, a high-speed car chase wherein the child was in the vehicle. It was thought that Miss Victoria DeHart was under the influence of substances at that time, and she did leave the child in the car. The grandparents came to pick up the child. Ms. DeHart did try to retrieve the child a day or two later, got into a physical altercation with some family members, it looks like, and then fled the scene before law enforcement arrived. That was the original altercation. Since that point in time, until the filing of the petition, it would appear that the child was left with the grandparents without legal authority to continue to take care of the child, and against the will of Ms. Victoria DeHart, who did appear at one point asking for the child, but was denied by the grandparents at that time before disappearing again and coming to us here today from jail. Additional facts and circumstances for purposes of the plea, Ms. Thomas?
Thank you, Your Honor. I would also just, if the court would be willing to accept, I guess, recognizing the other portions of this record since we've been here on the preliminary hearing back in September. This is the first time that Ms. DeHart has been able to join us. And so for several months, she was not available to the child for care and custody. I think that in addition to the substance abuse concerns, the psychological, as Mr. McFarland noted, also some parenting education would be needed, and especially rebuilding that bond once she's available for some parenting time. And I think that there was a court report provided back in November, which would outline a sample of a case service plan. And I think that it is accurate in addressing, or sufficient in addressing, the issues that face Ms. DeHart at this time.
Does look like there's documents that were received by the court November 13th, 2024 and November 19th, 2024. Another set of documents filed January 6th, 2025. Are you asking about all of that, or a section of those?
Your Honor, for the factual basis, just the petition. I noted that simply for the record, so we can develop the case service plan and or admit it in the future based on those facts that we also have.
As to the factual basis, Mr. McFarland.
Well, I think what you stated in the petition is what we need, Your Honor. As far as the case service plan, I'm not objecting to that, but I do think a family team meeting or least my client discussing that with the ongoing worker would be the way to proceed. I'm not sure that she has viewed that potential case service plan or had opportunity to discuss it. There may be some more things that she might need that are not in there.
Anything from you, Mr. Mott?
No, Your Honor, I'm satisfied.
Thank you. All right, so we'll, just to confirm, I have looked at the petition for purposes of the factual basis. Obviously, there have been some preliminary hearings and some other things that have been happening. But in short, I think the only additional thing that would be super relevant at this juncture for adjudication purposes would be the extended disappearance of your client. Mr. McFarland?
Yes, Your Honor. Taking a look back in November 27th, we had mentioned that there was ICWA inquiries as to paternal grandfather indicated native heritage. Do we have any documentation on that?
Okay.
And I'd like to at least ask my client the ICWA question again.
All right. Are you satisfied with the advice of rights and the factual basis of the plea?
That I am.
Ms. Thomas?
I am, Your Honor.
Mr.
Yes,
Bush?
Your
Very good. Court is also satisfied that the plea is knowingly, understandably, and voluntarily made with a full understanding of the consequences. And I would agree. I think as it relates to this case, we were looking for some Native American heritage searches, whether they were historical or current. Ms. Thomas, could you speak to that?
Your Honor, my file indicates that ICWA documentation was sent out on or about September 20th. The court should have received a memo on or about September 25th with that information. Would have been presented for our pretrial hearing or preliminary hearing that was set on September 27th, 2024.
A memo?
Yes, Your Honor, there should have been all of the, it's about 21 pages in length. And so the inquiry with the certified receipts and the petition as to what was sent, is included.
I've pulled up my notes. Okay, so it looks like on the legal parentage issue, we were looking for a copy of the order or the AOP and also a death certificate potentially for Mr. Tyler Hubble. The ICWA inquiry status was noted to be that the inquiry was sent and we received certified mail proof that it was sent to, looks like 6 tribes plus the BIA. So we would look for the green card receipts or any denial letters from those tribes as of today.
And Your Honor, I don't have an update on those.
All right.
Your Honor, I do have a copy of the AOP. I received that at the beginning of October. So I can email that to everyone if they do not already have it.
Very well. Well, and as I referenced earlier, I have a number of documents that are just floating in this file. So hopefully we'll be able to look at those at the initial disposition, or we can look at them today, however you want to handle that. But absolutely, I would need a copy of that AOP and then preferably a copy of the death certificate as well on the father. Including, of course, the update on the Native American heritage searches.
Yes. Your Honor, I would ask just to be able to submit any of those things at the initial disposition, just to ensure working between CPS, the department and the foster care agency, that we have all of those things for you.
That's fine with me. Okay, so did that answer your question then, Mr. McFarland, on the ICWA?
It did, Your Honor. Thank you.
Very good. All right, so for purposes of the adjudication order, I will indicate that there are several sections of MCL 712A.2B that apply in this particular case, specifically that home or environment by reason of criminality. And that includes, of course, the use of illegal substances as well, impacting the parenting of Mr. Hart, as well as failure to provide care and custody for the child or other care, in fact, as well, indicated as necessary for him. And now let's look for the initial disposition date.
It did occur to me, the one question I had is from my client, and if I could ask her that one.
Okay.
Ma'am, do you have any Indian blood in your family line that you are aware of?
Yes, I do.
Okay. And what tribe do you believe that might be?
I know we had Cherokee, we had Blackfoot. I think that's what I know of so far.
Are there any relatives alive who could provide any additional information on that?
No, but my mom's dad, my grandpa Joe, right before he passed away from lung cancer, he had done a search, and he knew that he had enough, and that my mom would have enough, and I should. So.
Okay, I can't understand what you're saying. Could you slow down, please, and get a little closer to the microphone?
Pick up with your grandfather.
Yeah, my dad and my grandfather. So my mom's side and my dad's side both have it.
Thank you.
All right, thank you.
And would your mother or father be to contact people to ask that question?
If they had the paperwork.
If they can provide the worker with any knowledge that they have.
I'm not quite sure, but they might be able to. If yes.
Okay, thank you. That's what I need to ask you.
Thank you. It would appear that the inquiry was conducted in cooperation with the grandparents, but we'll ask for the confirmation of that at the next hearing, because I know Mr. Hart was not available to us at that initial inquiry stage, and nevertheless, there were 6 tribes plus the BIA that were requested to do that search, including a couple of different Cheyenne and Cherokee tribes. But we can continue to look at that moving forward. All right, anything else before we find our disposition date?
No, thank you.
Very well.
Pictures, not the pictures.
Looks like Friday, February 7th at 2:30 is available.
That's fine by me.
That works, Your Honor.
Right, very well, thank you. Mr. McFarland, would you like us to make some time for you to talk with your client about the proposed case services plan that was provided before we let her go for today, or would you prefer that she just try to get a hold of you if and when she...
How about now? I think that'd be the best way for me to do that.
Okay, very good. All right, so Mr. Hart, what's going to happen now is Mr. McFarland's going to talk with you about the proposed case services plan, which will be what the court will be discussing on Friday, February 7th at 2:30 for purposes of your initial disposition. The case services plan would track progress that's been made by you on some of the issues that were identified today as you try to improve your situation both for yourself and your child. Do you have any other questions?
No, Your Honor.
Very good. Between now and when we come back on the 7th at 2:30, the child will remain placed with relatives from both sides in continuing to enjoy that bond and support as Ms. Victoria DeHart begins her journey in deciding what services she might want to undertake so that she might be available to her son in the future. For now, he is placed in the safest and least restrictive circumstances. Would you wish to make any other reports or comments today, Mr. Mont?
Your Honor, I did file a physical report, but I did meet with the minor child on Friday at his school. He's in Head Start, he's doing well. I spoke with both the DeHarts and the Hubbles with regards to their stipulation on parenting time. They're close to 50-50 at this point, and both sides are doing well. There's little hiccups, but that's to be expected. The minor child is adjusting well to overnights that he didn't have previously with the Hubbles. Head Start's going well. They said there's no developmental delays that they can see. My one question was, I thought at the last hearing family counseling was ordered. I tried to find that somewhere. I didn't see that, but I just wondered if that was something that the court would want the family to participate in. I know there is one in Brooklyn that is close to both sides residents and willing to help.
Yes, that is accurate. I had indicated that that should be part of what happens. The order dated 12/5/2024 in fact says JH should be referred for individual and family therapy, which should include both sets of grandparents.
Okay.
So you're absolutely right, and that should be something we'll be looking at the next report.
Yeah, sure. I don't believe it's started as of now, but hopefully they can get that implemented.
Agreed. Thank you for asking.
Your Honor, how do we wish to address parenting time in the event my client is released prior to our next court hearing?
Well, we would leave that to be arranged by the caseworker, which means that she'll have to be reaching out to Ms. DeHart to monitor obviously her progress on her criminal case, as well as to find a way that best serves her opportunity for supervised parenting time between now and when we come back. In other words, family team meeting is the best way to approach that, or to allow the caseworker to tackle that, considering that your client's coming to us currently from Monterey County Jail, and then there may be changes between now and when we come back.
That's what I anticipate, Your Honor.
Any other issues for today?
I'm just checking to see if attached to the court report is a case service plan.
Yes, it was attached to one of the packets. I have a proposed one up here if you need it.
It's not for today, Mr. McFarland. It was for the November hearing.
I'll borrow the court's pack, maybe.
Okay.
Oh, I do. I have the proposed case service parent plan agency agreement. I have it.
All right, anything else for today?
I may stay here if it's easier for me to read this and then Zoom with her than
Sure.
hit screens.
All right, we're gonna leave Mr. McFarland in the courtroom. Thank you all. Yes, are you Mr. Hart?
Yep, I'm Mr.
Yep, come on up here. Well, wherever you want, really. Mr. McFarland is your attorney, so if you're comfortable.
That's your
We're on record for the initial disposition as it relates to Mr. Hart. May I have the names of our participants, beginning with our guardian ad litem?
Katharina Dumont, lawyer guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Ms. Della Garza.
Brandy De La Garza. I'm the foster care worker from Fostering Solutions.
Michael McFarland, representing mother. Please introduce yourself.
I'm Victoria DeHart.
Thank you. All right. Ms. Dumont, whenever you're ready for your report.
Your Honor, I did file a written report yesterday as well. I met with the minor child yesterday. I was scheduled to meet with him at school, but they did have a snow day, I believe today and yesterday. So I met with him at his maternal grandparents' house. He's doing well. He was having a great day, not having to go to Head Start. He's doing really well in Head Start. He did also advise me that he did have a visit with his mom, and he had a really good time with that. He said that she brought him a toy. He was excited to get to see her. I've reviewed her case service plan as well, and I think that her completing those services is going to be in the best interest of the minor child. He's doing well with the current parenting time stipulation that has been placed. And I think at this point, continuing to do supervised parenting time is in the best interest of him as well.
Thank you. Testimony this morning, Ms. Thomas.
Thank you. If Ms. Della Garza can be sworn in, please. Thank you.
Sure, Ms. De La Garza, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Ms. Thomas.
Thank you. Ms. Della Garza, you've prepared a court report for today's hearing, correct?
Yes.
And part of that includes the case service plan for Ms. DeHart.
Yes,
With-
that's correct.
Okay. And then it looks like some documents establishing paternity and then confirming Mr. Hubble's death.
Yes.
Okay. And then you also list ICWA, and then Ms. DeHart had completed several trainings online, it looks like, and you've included those certificates. Are there any other documents that you're aware of that have been circulated since you've provided this packet to the court and parties?
No.
As it relates to the ICWA documentation, on my version, it's scanned in where there's like the return receipts, I think 1 or 2 letters. And then at the end is the DHS 120. To the best of your knowledge, is the 120 the document that was sent to all of the tribes?
Yes, it was.
Okay. To the best of your knowledge, have there been any more letters received by the agency or the department, either confirming or denying eligibility?
No, there have not.
Okay. At this time, what is the permanency goal for this child?
It is reunification.
And what are the current barriers to reunification?
The current barriers are that although the child came into care in September of 2024, Mr. Hart was not able to be located until she went to jail on December 11th, I believe. And so now that she was bonded out, she has begun, she's just begun, I should say, working on her case service plan. So that includes looking for appropriate housing, employment, or some sort of legal income, emotional and mental stability. And we are also getting her set up with a psychological evaluation and also the Orchards program for the parenting times.
As relates to, I think one of the main concerns also was substance use for Mr. Hart. Are there any voluntary services that she's engaged with since she's been located?
She did complete a screen with me on January 29th when we had our family team meeting. I don't have those results back yet, but hopefully soon. She's supposed to be screening twice a week through her bond conditions with the criminal court case that she has. And she's supposed to be doing that twice a week, but they've only called her on February 5th to test. And they did say that the results were, she tested positive for Suboxone and THC.
And to the best of your knowledge, does she have a prescription for the Suboxone?
I do know that she had psychiatric services while she was incarcerated. But when I met with her on the 29th of January, she had stated that she was not taking any medication at that time.
Okay. At the family team meeting, were you able to discuss the case service plan?
Yes, we did go over the safe case service plan together.
Okay. And do you believe that the case service plan as proposed is adequate to address the barriers to reunification?
Yes, I do.
And you mentioned that she had screened for you and has so far screened through bond conditions as well. Are there any other voluntary services that she has started?
She did sign a release for me with the drug court so that I was able to get those drug screen results and continue getting them. And we are also in the process of setting up her psychological evaluation and, as I mentioned, the Orchards program for parenting times. And she also did attend a parenting time on Monday, this past Monday.
And how did the parenting time go?
I was not the supervisor, but the notes stated that it went well and that she, as Miss Dumont stated, she took toys for the child, and so there was no concerns during the visit.
Okay. Great. And then I know that for this kiddo, there are two sets of grandparents, and they are both receiving grandparenting time. How is that going for them?
I believe it's going well. We're still looking into getting therapy sessions going for the family. I've
tried contacting a couple different places, including Parkside. I've called Hudson and Adrian Family Medical Center. And I also called the Giving Tree in Brooklyn that was mentioned in court the last time. My only concern with which hopefully the court can also help address this, but my only concern with the Giving Tree is that the paternal side of grandparents do work in that area, so they do know people at the Giving Tree, so I wasn't sure if that was a conflict of interest or not.
Were any of the agencies that you called available to provide the family therapy?
The only one that was the Giving Tree, and
Okay.
they don't take his Medicaid, but the paternal grandparents did offer to pay for that if needed.
Okay. Did you have, as relates to the Giving Tree, did you talk with any of the providers there?
The therapist and I have been playing phone tag, but I did speak to the secretary there.
Okay. Okay. And it's your belief that the therapist knows them directly, like personally?
I'm not sure if it's the director of the Giving Tree. I don't think it's the therapist herself. It's just someone within the Giving Tree.
Okay. All right. And then as it relates to the kiddo, just any updates on how he's doing?
He's doing really well. When I saw him, it was actually my first time meeting him since I just recently got this case. But he did really well. He did talk to me and showed me his toys and his other belongings in the home. He was homesick from Head Start when I was out there. There's lots of things going around, but other than that, he is doing very well, and he's up to date on all of his medical and dental exams.
Is there anything else you'd like the court to know?
Nope, that's it. I think the only other concern with mom is just right now she's bonded out, but I do know she has another she hasn't been sentenced yet for the criminal side. But she does have a criminal court hearing this month, I believe.
Okay. Right. Thank you. With that, Your Honor, I have no further questions of this witness and move to admit the report with the attachments. Your Honor, I know that at the last hearing, we also discussed there were several documents kind of floating in the file. I know that Ms. Brinker had filed reports for all the pretrial hearings that we had. And I'm not sure, given that she's no longer with the agency, if the court would still like to accept those at this time, or if I feel like they were relevant at the time that they provided updates on how the child was doing, efforts to locate mom. So I would ask the court to accept those, but I don't have a witness to lay the foundation for those.
Any objection?
I have no objection. I have reviewed those, Your Honor.
No objection.
Thank you. So that's going to include then the documents filed on January 6th, 2025, which is a court report, and documents filed November 19th, 2024, and November 13th, I think has more to do with a notice. That's a DHS 30 notice. But yeah, so there's been a number of documents that will be included, and I'm happy to hear the attorneys. I've had a chance to look at those because I also think they're very relevant. It includes the initial copy of the stipulated order regarding visitation for the grandparents, for example, some other good information about what was happening with the child between the time of his removal and currently. So I'm happy to receive those. Okay, questions for this witness, Mr. McFarland?
I do. One was that you said the test was given by the probation department of my client. Is that what I'm hearing?
Yes.
Okay. Okay, I'll let her deal with those results at that level. What's your proposal for her parenting time right now, as far as duration and frequency?
Right now I went by the one of the court orders that stated once a week for 1 hour, just to start out with, because the child has not seen her for so long. So we just wanted to kind of ease into those.
So can you tell us what that easing into it might look like until it's expanded into maybe, let's say, 3 times per week at 2 times per visit, which is more or less standard? Can you tell us what you might be looking for as far as a time frame if everything goes by?
Yeah, I would like to do a couple more weeks of just the 1 time a week to see how those continue going. And then after that, then we would look at moving up to twice a week and go from there.
Okay. And would there also be some consideration of perhaps a family type visitation, even if it's supervised, being at my client's maternal or at her aunt's house, a maternal aunt's home? Would that maybe be explored?
Yes, I can definitely do a home visit out there and run background checks and things like that, just to make sure that's an appropriate place.
I'm going to call my client to give us updates on her criminal status, but where should her priorities be on the case service plan right now? She has to prioritize.
I definitely think, I know she said that she was not looking for employment right now because she's trying to get into drug court. So I was waiting on an update from that, but I do think that getting the psych eval done and the substance abuse evaluation done is important, and obviously continuing doing the drug screens.
And those have been scheduled, those appointments, correct? The psychological and the other?
No, we're working on getting those scheduled now.
Okay, gotcha. Okay. I have no further questions.
Thank you. Any questions, Ms. Dumont?
No, Your Honor, thank you.
All right. Anyone else you'd like us to hear from, Ms. Thomas?
No, Your Honor, thank you.
Mr. McFarland, you wanted to call your client?
I do, Your Honor.
Okay, Deputy Ames, swearing her in. Why don't you come on up to our witness stand?
I know you were telling me a little bit about the status of your criminal case. Can you tell the court, enlighten us?
Wednesday, I go in at 8:30 in the morning, and they my Sam Valero is my lawyer for that one. Yep, appointed attorney, and he asked me if I was comfortable doing that, and I told him yes, but we have not made it to the point of them offering it to me.
I'm sorry, what are you going in on Wednesday for?
For the fleeing and eluding.
Okay, so is it a sentencing or what is it?
It's a preliminary examination of the circuit court.
Okay, thanks.
Yeah.
You believe they may offer some type of
That's it. He said, so that's what I'm hoping for.
I believe you told me you anticipate there might be some type of drug sobriety court or something?
Yep, it's 90 meetings in 90 days for the first phase. And so that's the only reason why I have not, I have actually tried to get a job and I've been offered it, but I told them that they need to wait at least a week. I didn't tell them the exact reason yet, but to see. So I do have the Dollar General down the road lined up possibly to do, or they're hiring there, and a couple other opportunities.
And will you keep your worker informed as far as what your status is on that?
Yes.
Any concerns you have with working through your case service plan?
No.
You understand that's your roadmap of what you have to do for reunification?
Yep.
There's already some time under your belt, which you haven't been able to do that. You understand that?
Okay. Yeah.
Any questions or concerns you want to bring to the court's attention today?
I'd definitely like to be retested for that one, for the thing, and talk to them. I know I've been on antibiotics, so I don't know. I've given them to my probation officer, so maybe he can figure out something of why that would be like that.
You're telling me that you've not been on Suboxone? Is that
No,
correct?
I have not been on Suboxone.
So if your worker wanted to give you a drug test today, you're saying go at it?
I
you
would
have
take
no
it.
problem.
Yep, exactly.
Okay. I have no further questions, Your Honor.
Okay, is that court date Wednesday for the fleeing and looting the only criminal matter that you're attending right now?
Yep, there's a is it in like a felony or
Any criminal matters?
Okay, on the 11th I have one, but we were hoping to get it dismissed. It was for my mom for the domestic.
So is that like a pretrial or something?
I've never even been in there for it yet.
So it's an arraignment maybe?
Yeah, possibly, yeah.
Okay.
But she had signed papers for it to just have it dismissed.
Okay.
But other than that, no, that's all. That's the only ones I have.
So the caseworker mentioned that you were drug testing for probation. Are you on probation or bond conditions, or what's the status?
Yeah, on both.
So what are you on probation for?
Just till I get in there, I guess probation from the accident.
Okay, did you take a plea on something?
No.
Okay,
no.
so is it all pending right now?
Yes.
Thank you.
Sorry, I'm so sorry.
That's okay.
Yeah.
I just wanted to make sure I understood what was happening.
Yeah, I know I've not been sentenced to no pleas, nothing.
Okay.
Yeah.
All right. Any questions, Ms. Thomas?
Mr. Hart, is the fleeing and eluding, is that, I know that judge just asked you that, but you're stating that's the only charge other than
No, I
the
have two.
domestic?
They're all combined into that one now.
Okay, can you try to wait till she
I'm
finishes
so
her
sorry.
question first before you answer?
So
Because
sorry.
when we overlap questions and answers, it becomes difficult to make a transcript.
Sorry.
That's okay. Ms. Thomas, could you ask your question again, please?
So I'm more wondering about the individual charges that I know that they're combined all in one into this one hearing, but what are the individual charges?
One was paraphernalia and possession on school property. I was walking my dragger and I had a warrant for that domestic violence that I did not know of. And then another one was the last one where I went in was just a paraphernalia charge from misdemeanor.
So the fleeing, so just so you know, I'm on my court, and in circuit court, it shows that there's a felony fleeing, 3rd degree, a misdemeanor operating with the presence of a controlled substance, and a misdemeanor operating while intoxicated.
Yep, on that one charge. Yep, exactly.
Those are 3 separate charges. From
the one event, that's not what I'm trying to say. I'm so
Okay.
sorry.
Okay.
Yes. Yep, that is correct.
Okay. Okay. Now so that makes sense now. Great. And the working situation, is it your opinion that you wouldn't be able to attend work and an AA meeting every day?
I would if it was just a normal probation setting. If I do get offered the recovery court, it's 90 days and 90 meetings. So if I would possibly try to still do it, but if a job wouldn't work with me on doing that, you know what I mean, every day, that's the only reason why it would stop me.
Have you discussed that with your attorney and how many people in drug court have full-time jobs?
I didn't know. I looked at the first phase and I didn't know if it said seek employment. I didn't know it was because of that. I've not confirmed this with my lawyer anyway.
Okay.
But yes,
I've
been looking for a job already.
And are you attending any AA or NA meetings?
No, I'm about to set them up as for Catholic Charities.
Okay. I have no further questions, Jenna. Thank you.
Any questions, Ms. Dumont?
Yes, Mr. Hart, how many days of sobriety do you have currently?
From jail, I spent not 50 days, was it 40 days? And then from now till now, you know what I mean? So it's still, I've been released from jail till now and during jail. So from December 11th.
So do you think would you agree that you're early on in your recovery and you need a lot of counseling, or where would you put yourself at?
I mean, I wouldn't go back to save anything at this point, you know what I mean? But yes, I would take counseling. I did have a therapist before. She ended up moving places and I tried a different therapist, but I'm willing to have another therapist, of course. Okay. I do counseling for anything to do with that.
Okay. And you're agreeable to the case service plan that you signed?
Yes, of course.
Okay. And how do you think your parenting time with your son went this week?
I mean, I missed him so much. It went wonderful for me, and I think he really enjoyed it. We had a lot of fun. We got to play different games. We played in a little school bus tent, and Doc was driving around, with the dinosaurs carrying them. So I had a great time.
Okay, nothing further. Thank you.
Any redirect, Mr. McFarland?
Just briefly, are you going to any AA or NA meetings right now?
I've been out for a week and a half, and I plan on going. I have not done one yet. No.
You know that down in district court, they have a list of all the NAAA meetings and their times?
I did not know that.
Okay, just to let you know.
Okay, that'd be great. Thank you.
You may not also know, but that those meetings might also offer you a sponsor, so that if you have an urge or concern or feeling down or like you have to use, that somebody can step forward and give you a hand. You understand that?
Yeah, I did not know you could get a sponsor like that, but that would be great.
Okay. Do you have any support right now that you look for example, your aunt or anybody else to help?
My aunt, my family, my grandma. I got my aunt, my grandma's sisters.
Are we hearing that you're going to explore AANA as soon as possible?
Yes.
Okay. I have nothing further.
Any other questions for this witness? Counselors?
No.
No, Your Honor.
Thank you for your testimony. You may return to your seat.
Thank you.
Anyone else? Mr. McFarland?
I have none.
Okay, Ms. Dumont, anyone you'd like us to hear from today?
No, Your Honor. Thank you.
Okay. All right, comments in closing, Ms. Thomas.
Thank you, Your Honor. At this time, the agency is still recommending the goal for unification for this kiddo. It is the initial disposition, so we are asking the court to adopt the proposed case service plan as our guiding tool moving forward with Mr. Hart. I know that she's in the very early stages of sobriety and perhaps even maybe pre-contemplative. It's a little concerning that some of these very basic steps have not been done to really get a grasp of sobriety. There are NA and AA meetings freely available at any point in time, and it would seem that someone who is committed to sobriety, it's one of the first things that they would look into upon release from jail. And also still the lack of communication with the caseworker. The grandparents, as the report indicates, had to inform her that Mr. Hart was released rather than Mr. Hart taking the initiative to make that contact. So it seems that there is quite a bit of work to be done here. Hopeful for Mr. Hart. And we are just asking for the court to allow the department to continue to supervise the parenting time and expand on that as it sees fit. Thank you.
Comments, Mr. McFarland?
I think my client understands now that it's her job to be proactive and not to wait for people to get in touch with her, but for her to reach out to her worker, for her to reach out to AA, for her to reach out, and if she has any questions, to ask and not wait to be asked. So I think she's heading in the right direction, and we are very hopeful that parenting time will be successful and will expand. She signed the case service plan, she understands it, and she has her marching orders.
Thank you. Any comments, Ms. Dumont?
Your Honor, I would echo what Ms. Thomas said with regards to keeping the goal at this point for reunification and asking the court to adopt the case service plan and continuing to have those supervised parenting times to see if progress is being made, along with substance abuse counseling and drug screening, I think is going to be the biggest thing that we're going to need to see. But at this point, I do think it's in the best interest of the minor child to continue to have some contact, supervised with his mother, and have the goal still be reunification.
Thank you. The court finds all interested parties were given notice for purposes of today's hearing. I know we sort of moved this at the last minute from this afternoon to this morning, so thank you to everyone who accommodated that change at the last minute. I have also reviewed the updates and the proposed case services plan, and I do find it necessary and appropriate. It will become part of today's order And it will be our, if you will, measuring stick to see what the progress is that's being made by Ms. DeHart in the future review periods. We'll be parenting time as supervised. I would look for you to, and Ms. Delegars, I apologize if I missed this, check in with Ms. Brene Moore. She does a great parenting reunification or reintroduction program in addition to some family therapy services. So it might be a provider that would be able to satisfy both ensuring that Ms. DeHart connects successfully with her son moving through parenting time, but also is able to navigate through some of those conflicts that are arising between the two families. I did note in the court report that I'm glad that both sides of the family are getting time with this child, but there does seem to be some conflicts, and the child's trying to navigate what many children do when they're sharing households, which is 2 sets of rules. So the family counseling is still of paramount importance. Check in with Ms. Brene Moore to see if she can offer a couple of those services to assist in this file. As far as whether or not there's a conflict with the other option, I would leave it to the facility. If it's the only available facility, then I would direct the parties to cooperate and then to go from there. Most facilities will have more than one service provider, and or even if they know that person, if it's an effective service for the family, the point is to even things out for the child. And so I think the most important thing is right now is getting them into that space to start that work before it affects this child any more than what he's already been through. As I've reviewed in prior hearings, the child has had extensive periods of time with both sides of the family. Both sides of the family love him very much. Obviously, his mother is enjoying her time with him and loves him as well. So there's lots of good supports for him. We just have to make sure that it's going to be streamlined and supporting him moving into and through his childhood, despite the challenges that and the supports that he's had in his short life. In the meantime, the child will remain where he's placed in the shared custody of his grandparents on both sides, as we kind of visited already, with mom continuing to visit with him and work on her bond and her sobriety and some of the other challenges that she's working on at the time. That is the safest and least restrictive under the circumstances. Ms. De La Garza, did I address all of the questions that you asked me about today, in your opinion?
Yes, you did. Thank you.
Okay. All right. Well, I'll look forward to the updates in our next review hearing. And let's go ahead and set that for May 6th at 10 a.m. That will be a permanency planning hearing as well. Consider that motivation, Ms. DeHart, to be serious about your services, both for yourself and for your son. All right, unless there's any questions, we'll see you at 10 a.m. on Tuesday, May 6th. I'll have that order for you in a few minutes.
Thank you, Your Honor. The court have my client's current address, Your Honor.
For the first regular review in this matter, may I have the names of our participants, please? And we are on YouTube, so if we can refrain from using the child's name.
Kennedy Mossler, guardian ad litem.
Ms. Taja Thomas, counsel for the department.
Ashley Beach, I'm the foster care supervisor from Fostering Solutions.
Michael McFarland, representing mother. Please introduce yourself.
Victoria DeHart, mother.
Okay, let's go to Ms. Dumont for her report.
Yes, Your Honor, I was able to meet with Jamison at Addison Schools, where he's attending Head Start. He's doing well in school. His teachers say he's a joy in class. He also has a lot of friends, plays well with others. When I spoke with him, he was excited for his later visit with mom. He does love both sides of his family, both sets of grandparents and the kids and nephews that come, cousins that come with each. Miss DeHart is doing really well. She's been clean since December of 2024. She continues to make every parenting time. I was also able during this reporting period to observe a parenting time with her and the minor child. It seems like they pick up where they left off. She brings them snacks. You can tell that they play well together, and she's got appropriate conduct with him. It does look as well like she has employment. I think she's showing consistency, and I agree with the department that she needs to continue to do that. I think the minor child is at the heart of this case, and I think it's encouraging to see that some family counseling sessions were attended. But I think, you know, due to the report, there still isn't enough for Ms. Moore to make a recommendation on if the minor child should be brought into it or not yet. I saw there was a bunch that were missed as well. So there was limited meetings to make a recommendation on how to go further. So I think more time is needed to establish sobriety on mom's behalf, considering the reasons that were brought the minor child into care. And I think the current placement with the 50-50 between grandparents is the least restrictive, meeting all those needs and appropriate at this point.
Yeah. Witness testimony today, Ms. Thomas?
Thank you, Your Honor. Mr. McFarland, do you intend on calling your client or would?
I do.
Okay, then I'll call Ms. Beach, Your Honor. Thank you. State how you are familiar with this matter.
Yes, I have been assigned as the foster care supervisor on this case since Jameson came into care in September of 24.
And as the supervisor, how often do you review this case file or have contact with any of the parties involved?
I meet with the worker at least monthly, formally, to discuss this case and its updates and any needs or concerns. And then I've also participated in family team meetings with mother and placement and other relatives.
Great. And have you had the opportunity to review the court report that was submitted for today's hearing?
Yeah.
Okay. And to the best of your knowledge, are there any updates or modifications that need to be made to it?
Just that Misty Hart has secured a sponsor for NA, and she provided proof of that to Ms. De La Garza.
Wonderful. And at this time, do you believe that there would still be a risk of harm if the child were to be returned to Mr. Hart's care and custody today?
We do, just based on the fact that Mr. Hart has only just recently obtained sobriety. So we are hoping to see her maintain the sobriety for a minimum of one more reporting period before we really progress towards reunification.
And during, excuse me, the report is very favorable for Mr. Hart. Have there been any updates or meetings about how parenting time will transition into unsupervised or more frequent and or longer duration?
Yes, that's something that the worker and I discuss regularly. And then we did complete a home visit in Mr. Hart's residence this reporting period and discuss that as well. Our hesitance has been that she still has pending criminal charges and has yet to be sentenced. And I believe that they are felony charges, but I know that her and her defense attorney for those charges are hopeful that she'll be able to take a plea. So she is scheduled for, I believe, sentencing at the end of the month. And as long as she is not going to serve any jail time, we are looking to increase in frequency and duration and move towards unsupervised after that.
Wonderful. And the pay stubs are a little grainy on the report, but it looks like she's also providing those on a regular basis.
Yes, she is.
And at this time, are there any outstanding referrals or services that Mr. Hart needs to engage in?
No, not at this time. She is participating in all recommended substance abuse treatment and drug screens. She's also engaged in Orchard's parent education. We had initially recommended that she participate in a psychological evaluation, but now that her substance use issues are under control, we really don't have concerns in regard to her overall functioning. So we let her know that we would not be requiring that referral of her as long as she maintains her stability and shows us that she is capable of parenting as long as she stays sober.
I'm struggling to find the words how to ask this. Did the substance abuse assessment explore the underlying cause or reason for the substance abuse disorder?
I would have to reference the initial assessment. I'm not sure if that was included or if it was just reports. It looks like we just have the monthly reports included with this report, so I have not had the opportunity to review the initial assessment.
Okay. But generally, it seems that mom's functioning is very well during this review period. Is there anything, let me kind of backtrack though. The report from Miss Moore doesn't read as well as the court report regarding how the grandparents are getting along in this case. Can you just give us a little more information about what you guys see on the day-to-day and how they are functioning as a family unit?
I think on the day-to-day and from what Brandy has heard, they communicate okay with one another and they follow the plan that has been put into place for shared time with Jameson. We had referred them to Miss Moore just so they could work on their communication with each other, and in the hopes that they would be able to do so effectively once we're out of the picture. But it does appear that sessions aren't being attended as recommended. So that's something that we will discuss with the caregivers further too, because it really is just, we're hoping that it can help them secure a more positive relationship as they continue to share time with Jameson and obviously share love of him too.
In your family team meetings, are these discussions that you're also having with Ms. DeHart of how this might look once reunification is achieved?
I've only attended one family team meeting with Ms. DeHart and we did not discuss that, but that's something we can discuss in future meetings.
And is there anything else from your court report or from the court report or your knowledge of the case that you believe the court should be aware of?
I don't think so. I mean, just that we are really proud of how far Ms. DeHart has come over the last few months. And we try to tell her that as often as we can.
Wonderful. Well, thank you for your testimony, Ms. Beach. And at this time, Your Honor, I would ask the court to accept the court report with its attachments.
Objection.
I have one issue with the court report, if I could voir dire. My client brought to your attention that the court report references her initial arrest was on possession of methamphetamines and was cocaine. Didn't she bring that to your attention?
She did.
Would you agree that that should be amended to reflect an arrest on cocaine?
I would be agreeable. I don't have the criminal history in front of me, but I mean, if that is what she was arrested for, we would be agreeable to a change to that.
With that, no objection, Your Honor.
Where is that at in the report?
My client doesn't have the report in front of me, and she brought that to my attention over the telephone, so. I can just have her testify, my client, Your Honor, so.
All right, yeah, because I'm not seeing it.
I'll do that for expediency. I intend to call her anyway, so.
Any further objections?
Nope.
Very good. They are received then. Questions, any additional questions for this witness?
Yes, my understanding is my client has a plea on September or May 28th, and then sentencing would be sometime after that. So family team meeting, what are we looking at to determine what parenting time will look going forward and how it might expand? What time frame, before sentencing or?
I'm not super familiar with criminal proceedings, but if the plea was accepted on May 28th, I think we could schedule a family team meeting for sometime after that to talk about how we would increase. I guess I don't know if a plea is accepted, then if she could still be sentenced to jail.
Typically there's a plea and then there's a sentencing sometime after that. So
I think just based on how things have been going and if they're willing to accept the plea, we would be willing to meet after the 28th to discuss how we progress.
My understanding that her residing with an aunt can be considered a good thing, as there's another source of support there for her. Would you agree with that?
Yes.
Okay, and the house is acceptable, is that correct?
That is correct.
Just one last question. Do you know what her date of sobriety is? I know you said it hasn't been too long. How long has she been sober?
I don't have her date. I I believe it's December of 2024. But then there was a positive screen in January for methadone or Suboxone. So I'm not sure of the exact date.
Do you happen to recall that was, I think, the court acknowledged and everybody did that wasn't heard?
Oh, no, I was not aware of that. So I do not have the sobriety date.
Okay, no further questions.
Any questions, Mr. Ma? No questions. All right, is the foster care caseworker looking at potentially show causing the placements for failing to cooperate with that family therapy? Because I can tell you also in their civil agreement, that was part of what they were supposed to do in order to improve those conditions of communication for Jameson.
We have not discussed that yet. We can if you would like, but I would love to start with we will have to show cause you if you don't comply with this and see if we can help them take it more seriously.
I agree with that approach.
Okay.
I just wanted to signal to you that I am ready to talk with them on record if need be.
Okay, we will let them know.
Thank you.
Yes.
All right, any redirect from you, Ms. Thomas?
No, Your Honor, thank you.
Thank you for your testimony. May return to your seat. Thank you. Any other witnesses?
No, Your Honor, thank you.
Mr. McGraw?
My client, please.
Okay, Ms. DeHart, come on up to our witness stand.
Mr. Hart? Okay. I think what the attorney for the agency was asking the worker is, what are your triggers that caused you to use the last time?
I had anxiety before. My therapist has deemed me moderate anxiety now, so I am okay with dealing with stuff on a regular basis, better than I was with the support of readings and my therapist. And I have a women's Bible study who's also a recovery support coach. So I'm constantly in contact with all of these people.
Were there any particular triggers to the anxiety, housing, employment, anything?
My great grandma had just passed away. We were moving back to a house, my grandma's, which was fine, but it was just a lot going on. The death is mostly my trigger.
Okay, if something were to happen traumatic down the road, who would you go to for support?
My sponsor, I have probably my Bible study, the recovery coach, Stephanie, she's so amazing. I have so many things in my toolbox now. I have my therapist.
You understand these hearings are typically scheduled every 90 days, correct?
Yes.
So it'll be your responsibility to let the worker know what happened at your next court date. Do you understand that?
Yes.
Okay. And you're agreeable to have a family team meeting about how the schedule should look like, integrating into even possibly overnights?
Of course.
And I know you've discussed with me what's available, and you'll be willing to discuss that at the family team meeting, correct?
Of course.
I think every day for 2 or 3 times every day, you've been sending me AA proof, correct?
Yes.
Or is that NA also?
The NA, they aren't very good at sending email attendance. I've attended them, but they don't send the attendance.
Okay, but I think you've been sending them to me every
Yes.
day, correct?
Yes.
Have you been getting them to your worker also?
Yes.
Okay, great. Case service plan is for you to make sure that you're successful. Is there anything in the plan that you think needs to be tweaked in order for you not to have to come back to court after this case is dismissed?
No, I do not. I think we're all working together quite well. You know, everybody seems to be, I've had a call with Ashley, asking if there was any problems with my worker, and I do not believe anything's wrong with Brandy. I think we all understand each other quite well.
Okay, so is the place where you're living right now, do you think that'd be acceptable for overnights? Is there accommodations there?
Yes, there is. There's extra rooms. My aunt, she's amazing. We sit down and talk every night. That's probably also part of my support system. You know, she has the time for me, you know.
Any other commentary that you wish to give the court? This is your time to do so.
I think everything I've been doing is a part that I will be continuing after everything, you know, the things that I do with the meetings every day, the Bible studies every Tuesday, the therapist, you know, appointments, they all give me a weekly reset, and I only take one day at a time now. Well, before I would think about the future, which would extremely stress me out, you know, which would result in having anxiety. But when I focus on every day rather than the rest of my life, I've been able to seem to keep my thoughts and my anxiety in control and feel in the moment. So
you agree with the family team meeting after your next court date? Is that what I'm hearing?
yes.
Okay, I have nothing further. We'll see if anybody else has questions. Oh, I do have one question, sorry. On that, you pointed out to me on the telephone that your original arrest was for what?
The first one I ever got in trouble with.
Well, there in the report, there's a reference that you were arrested on cocaine, correct?
Yes.
Is that accurate?
Yeah.
Or was it? I thought you told me it said meth.
So it's it said possession of methamphetamines, and part of it, and I just read it in a certain.
Was it possession of methamphetamines?
No, it was not. It was possession of cocaine.
You know about where on the report you saw that? Beginning, middle, end?
Middle of it.
Okay. What has always been your drug of choice?
Cocaine.
Thank you. Nothing further.
Questions, Ms. Thomas?
No, Your Honor, thank you.
Ms. Dumont?
Mr. Hart, are you looking at entering into drug treatment court upstairs with a plea, or?
Whatever they offer me, I will take the plea of.
Okay, have you been screened for drug treatment court upstairs?
As in recovery court?
Yes.
No, they have not asked me about it. We talked about it, but we don't know if they'll offer it now since I've done so good.
Okay, but if they do, is that something you're interested in?
Of course.
I think it's a 2-year program.
Yep, yes, it is.
Okay, thank you.
Any redirect, Mr. McFarland?
No, thank you.
Any recross, Ms. Thomas?
No, Your Honor.
Thank you for your testimony. May you return to your seat.
Thank you.
Any other witnesses, Mr. McFarland?
No, thank you.
Ms. Dumont?
No.
Very well. Comments in closing?
Thank you, Your Honor. It is always really exciting to come to court when parents are doing well. And so I'd like to commend Mr. Hart for really sticking to her sobriety and doing what she needs to do for herself, which makes her a healthier person for her child. I know that the workers would love to move towards more parenting time. However, there is the outstanding criminal stuff, and just for the safety of the child to ensure there's no disruption in his routine, I think it's appropriate to maintain status quo pending that the criminal case resolution. And it sounds like there's definitely a good plan to move forward. And there's no concerns about doing that, especially given Mr. Hart's progress and her appropriate housing. So with that, Your Honor, we're just asking for another standard 90-day review. And I think that's it. Thank you.
Mr. McFarland?
Oh, we agree with having a family team meeting after my client's next court date. And I have to agree, I think we're on the right path. My client's been demonstrating that. I know a couple times a day I keep getting her emails, and I appreciate that, that she's attending her classes. And this is what we anticipate will happen when somebody gets into this court, and she's taking the proper steps.
Your Honor, I'm in agreement with the department as well to maintain the status quo as of now, and ask for another standard review period, but Mrs. Hart is doing really well, and I believe that she'll do anything she needs to get her child back.
Yeah. While the court finds all interested parties were given notice for purposes of today's review hearing, I do find the reasonable efforts towards the goal of reunification are being made. Mr. Hart is making good efforts to comply with bond conditions and to maintain sobriety, which is great to see. I've already signaled to the caseworker as far as the court's position on the family members that are currently sharing caregiving responsibilities for the child in this case. And I will look forward to updates on that area moving forward. I'd like to ask the caseworker to look at the case history for Missy Hart. Her the grandparents of this child had already achieved a visitation order with this child. The only way that's achieved in circuit court is if they've established a relationship with the child to the extent that depriving the child of the presence in his life would be a risk of harm to him, meaning that the child has been in and out of care with both sets of grandparents throughout the period of time in his life. And I don't think Mr. Hart was here the first time I reviewed this and indicated to the family members that because of that, they were to arrange a shared supportive environment for him. But I say that because I I'm glad to see Ms. DeHart making progress, but there's certainly a very long history in this case. And there's an issue with even monitoring sobriety through the period of bond conditions and probation, because obviously there's a lot more motivation there for sobriety, not just reunification with your child, but also incarceration if there's failure. I also recognize that efforts towards sobriety were not made, nor even efforts to appear for these court hearings were not made until the arrest of Ms. DeHart. So her sobriety date is likely the day that she was arrested and taken into custody. And I sincerely hope that the upward motion that we're seeing is sustained past the motivation of additional incarceration. But because of that, I have significant concerns about the amount of time that we'll need to see sobriety from Ms. DeHart. So we'll look for the foster care caseworker to explore the idea of a juvenile guardianship in addition to what's happening here. Ms. DeHart is making herself a part of her child's life. And if she continues to do that and proves to be resourceful to him and to herself, then certainly we would look at reunification. But I also would like everyone to understand that juvenile guardianship is a very serious concern for this court, and it will only be available to Ms. DeHart if she continues to be sober and successful in establishing a healthy bond with her son. But I'm looking at not only the case that I have here before me since the inception of it, but also a very significant history for this child. And what permanency looks like for him is obviously of paramount importance to this court, and I'm sure to his family and to our caseworkers. So I just wanted to put that on the record for Ms. DeHart to hear, as well as for you to pass along to the family, in this case, on both points. So I'm looking for them to stabilize and make a healthy environment for them as they support the child, but also if they want me to look at juvenile guardianship moving forward, they're going to have to show me that they're able to work together as well for the child. So that's what my hope is that all of the people that love and care about this child will continue on an upward trajectory to support him, whether it's parents or grandparents, and that we'll be able to help support them in that with the services that are being facilitated by Fostering Solutions. So the child will remain in that relative placement during our next review period as Ms. DeHart continues to make her way towards progress in achieving sustained sobriety, relying on those supports that she's talked about today, and making her way through the challenges that she's got ahead of her in the criminal courts as well. And we'll have our next review on Tuesday, August 5th at 1:30 p.m. And that will be a permanency planning hearing as well, because that'll be our second review, and the child has been removed since September 27, 2024. Time flies when you're little. So we look at permanency always, and especially after 6 months. So the order will reflect the rest of the findings, namely that Mr. Mott is certainly a satisfaction for applications as well as our attorneys, and the caseworker for purposes of reasonable efforts. And unless there's any questions, that's all for today.
Should my client wait for a copy of the order, Your Honor?
Sure, it'll just be a few minutes.
Was that 1:30?
On record for a second review and a permanency planning hearing. May I have the names of our participants, please?
Katerina Dumont, lawyer regarding ad litem. Ms. Stasia Thomas, counsel for the department. Ms. Sala Garza.
Brandy De La Garza, the foster care worker from Fostering Solutions.
Michael McFarland, representing mother, your name?
Victoria DeHart, mother.
Thank you.
And Attorney Matthew Hotchkiss, I'm here on behalf of the Guardians, sitting in the back.
Okay, everybody has to slow down a little bit, please.
Michael McFarland, representing mother.
And then Victoria DeHart, mother.
Victoria DeHart, will you spell that, please?
VICTORIA
Thank you. Then Mr. Hotchkiss, you are here on behalf of whom?
I'm here on behalf of the Guardian. That would be Miss Cindy Hubble. She is seated in the back of your courtroom, Your Honor.
I'm sorry, refresh my memory. Is there a guardian?
I say Guardian, Your Honor. We had some, this is a complex file because there's actually a custody order in place with my client. There's a third party custody action. But for purposes here, she shares placement with the maternal grandparents as well. So I guess when I say guardian, it's the all-encompassing sort of phrasing, but it's a little complicated.
Well, you're in probate court and we have real guardians here too. So foster placement and third-party custodian or third-party custody action does apply, but for purposes of today, it's the placement.
Certainly.
Very good. All right, Ms. Dumont, whenever you're ready with your report.
Your Honor, I was able to meet with the minor child with his paternal grandmother's placement. He was playing in his room. He's healthy and happy. He did advise he likes spending time with his cousins at his maternal grandmother or paternal grandmother's house. They're all around the same age. He is too young at this point to state a preference. However, he enjoys spending time with both sets of grandparents and his mom. From the court report, Victoria is doing great throughout this reporting period, continuing to maintain her sobriety, doing her AA, completing everything on her end. When I spoke with her a while back, she had told me she would do anything to get her son back, and I think she's working on keeping her word to that. There was an incident after the court report was filed with a disclosure from the minor child with regards to the minor child's uncle, but who is also, I think, just a few years apart. They do share a room at maternal grandmother's house. The minor child did do a CAC interview. There was no specific disclosures made. However, Fostering Solutions did implement a safety plan in which the two minor children are not to be alone together, no changing in front of each other, no sleeping in the same room. Maternal grandmother indicated she would abide by the safety plan. There's just some concern if she's not at home, being able to monitor both of the minor children when they're together. With regards to therapy that has been going on between the grandparents with Brene Moore, I did review her report. Brene did have some concerns with the progress being made. As the court's aware, that's outlined. Concerns with being able to make progress moving forward. And having some healing between the parties. It seems like there's some animosity still, but I do believe that it would be beneficial to Victoria and Cindy maybe have therapy together as well with Brene Moore. The reality of the situation is that all of these people are going to be in each other's lives on behalf of the minor child. You know, and even if the goal at this point is reunification, Victoria is working towards that. And even when the minor child is reunified with her, Grandma Cindy is still going to have, you know, time with him. I don't think it would be in his best interest to remove her from his life at all. And before this case came in, there was a custody order as well. But I believe as of now, it's in the best interest to continue with the current placement 50-50 between the grandparents and the parenting time in place and leave it at the discretion of the department with regards to mom if that's supervised or unsupervised. And then just based on what the court's opinion is with regards to the safety plan that has been implemented. But other than that, the current plan is the best interest and the least restrictive.
Thank you. All right. Did you consider the child too young to express a preference in this matter?
Yes.
Thank you. Testimony today, Ms.
Thank you, Honor. I'll ask Ms. Delgarza to be sworn in.
Garza, come on to our witness stand.
Good afternoon, Ms. Delgarza. As relates to the court report you've provided for today's hearing, are there any updates or modifications that you're aware of that need to be made to it or any of the attachments?
The only update Ms. Dumont already had touched on about the allegations made. We did set up a safety plan that did include the things that Ms. Dumont has already mentioned.
And as it relates to Ms. DeHart and her compliance and benefit from her case service plan, how would you describe that within the last review period?
I am happy to be up here on this case because usually we don't get to say great things about parents, but Ms. DeHart is doing amazing. She's continued to either complete or continue to participate in services that are on her case service plan. As far as AA, she attends at least daily, if not more than that. And she also has been an opener for some of those AA meetings, helping run them. During this report period, she did complete the Orchards program satisfactorily, and she continues to participate in individual therapy through Catholic Charities. She was doing weekly, and then it moved to twice a month. And they actually recommended that she could stop, but she wanted to continue. So now she is just doing monthly appointments. But other than that, she's just doing great. Even at parenting times, one of the things that we did want to ask for guidance with the court is if we could move to discretion of them being supervised or unsupervised, just because she is doing very well. And the child also is observed to very much enjoy the visits with his mom and asks about having more visits. So she's just doing great in all of the areas.
Wonderful. And at this time, what would you say the risk of harm would be to reunification today?
The risk of harm today is that we are, since she was MIA at the beginning of the case and then was incarcerated, we would just like her to continue another report period, doing what she's currently doing, before we would recommend returning home.
As I know that at the last hearing, there was, I think Judge had instructed the team to maybe explore the potential of a juvenile guardianship. Was that done, or do you find a need to continue to explore that option for permanency planning?
I don't find a need for that at that time, just because of how well Mr. Hart is doing.
Okay. And based on your knowledge of the case or any conversations you've had with the family, once reunification is achieved, or if mom is exercising prolonged unsupervised parenting time, if she needs a caregiver, what would that look like? Like, if that's been discussed at all, daycare or anything like that?
I haven't discussed that with her too much, but I do know that she has family members that, including the placement, that would be willing to help with Jameson, and also he'll be going into kindergarten in the fall. So I have discussed with her, her working during the day or working like around their schedules, him possibly getting dropped off from the bus at her home and things like that.
Okay. And as it relates to, I know that there's several caregivers, and so this little one is pretty lucky to have so many people who love him. How do you, or Ms. Dumont had made a comment that perhaps it'd be appropriate for mom to engage in this family therapy that's been in place for the grandmothers. Have you talked with the family about that, or do you have an opinion on that?
I had spoken to the paternal side, and they also thought that was a good idea. I've spoken to mom some also about having sessions with Renee, with just mom and the paternal grandparents, just to try to mend the relationship that they have there, because as Ms. Dumont said, we don't want to see this kiddo, even if he is returned to mom, lose any of this family that loves him.
Ms. Moore's report indicates that the kiddo really, and it seems to be bonded and adjusted to both sets of grandparent or grandmothers, but seems to go to the paternal grandmother, unprompted or more regularly. Has she mentioned anything else to you in any of your conversations about whether she thinks that's significant, or is that just an observation?
She did state that she, wanted to continue therapy sessions so she could continue to explore that. The child, when she's spoken with him, has not been very open or has stated, whether he prefers one side or the other. But she did state to me that he goes more to the paternal side.
Is there anything else you'd like the court to know from your court report or your knowledge of the case?
No, just that mom is doing great. I did forget to mention that she's still continuing to screen And she has provided negative drug screens since she's been released from jail. She was doing them randomly weekly with through the courthouse, but now she's doing it through her probation officer, but she still continues to test negative.
Okay, thank you so much. And with that, Your Honor, I have no further questions of Ms. Dela Garza. I would ask the court to accept the court report and its attachments.
No objection.
No objection.
No objection, Your Honor.
Thank you. They are received. Questions for this witness, Mr. McFarland?
I do. Sounds as though what you're saying, my client is right on board where she should be at this point in time, or maybe above the curve. Would that be accurate?
Yes.
Is there anything that she should be focusing on that she's not focusing on?
I don't think so. I mean, she's doing all of the areas at the same time that she's been recommended or court ordered to do. So there's not one thing in particular, just to continue to maintain her sobriety and continue attending all parenting times. But she's doing very well.
How many visits per week, and what is the duration per visit?
She's currently getting 3 visits a week. She has 2 hours on Monday and 4 hours on Wednesday, and then 4 hours on Thursday.
You're saying that at the end of this next period, you would consider return home if she progresses as she is now, correct?
Yes, we're reunification services.
I would anticipate it's not going to be an instant home. There'd be increased parenting time perhaps during this period to integrate into that.
Yes.
What might that increased parenting time look like time-wise then?
We would be looking to move them up since she is doing so well, and the child's doing well with them. If we're able to do unsupervised, we would definitely be able to add more hours in as well around her schedule and his schedule once he gets into school.
Does unsupervised technically include perhaps overnights or not?
It can, yes.
And then when do you think that additional, if the court allows unsupervised or additional time, where do you see that increasing?
We could, if they are allowed unsupervised, we can get that increased as early as next week, I would say.
Okay. My client also indicates to me that if the court would be ordering some type of therapy between the adults, that she would attend if they'd be beneficial. Do you see a necessity or that it's beneficial? What's your position?
I do think it would be beneficial for her to have therapy, just her and the paternal grandparent side.
One therapist wouldn't be representing both of them, would they? Or how would that work?
I do think it would be good for Miss Moore to do it just because she already knows the family and has some of the backstory and things like that. But if other parties didn't think that was appropriate, we could look for someone else.
I'm just wondering, how do we keep the confidentiality? Ms. Moore would obviously be confidential, but you wouldn't with the other parties, maybe bearing their souls. Maybe give that some consideration, how that might work.
I can look into that, yes.
Okay. I have nothing further, thank you.
Okay, any questions, Ms. Dumont?
No questions, Your Honor. Thank you.
All right, Mr. Hodgkins, typically the foster placement is not an active participant in our review hearings. I would be willing to allow you to a limited extent to ask any questions. If you have any, now would be your opportunity.
Thank you, Your Honor. If I may just have just a few based on what I've heard from Ms. Dumont's testimony.
Go ahead. And Ms.
Thank
Dumont is not a witness. She's our guardian ad litem, so she's not able to ask any questions. Or you're not able to ask her any questions. She's a lawyer guardian ad litem. So that was just her report.
Correct, Your Honor. It was based on something that she had disclosed. This is what I was asking this witness about.
Very well. Go ahead.
Thank you. Ma'am, you had given a statement, I believe, that you were aware of an incident that recently transpired with Jameson that gave rise to a CAC interview. Is that correct?
Allegations that came forward, yes.
Allegations that came forward. And did you take part in that CAC interview process?
I did not. I spoke to the CAC before and afterwards, but I was not part of the interview.
Okay. And is there anything in your investigative process, both before and after that CAC, that gave you any cause of concern regarding the minor child's current placement?
So he did not disclose anything during that interview, but I did talk to the CAC about setting up some body safety meetings with him, which the CAC also thought was appropriate. So he is on a waiting list for that.
I see. And is it your position then that maintaining the joint cohabitation with the minor child, do you believe that's still appropriate in this circumstance?
I do. As Ms. DeMont said, we're kind of also looking for court guidance on that as to placement and things like that, because I know that was something that was brought up previously in the case.
I see. So you'd be willing to leave that in the court's discretion then to make that determination?
Correct.
Thank you. I have no additional questions, Your Honor. Thank you.
All right, any other questions, counselors? Any redirects?
Just one.
Go ahead.
Do you say buddy or body?
Body safety.
What is that?
It's just like 4 different appointments that he would have with the CAC to talk about appropriate touching, not appropriate touching, when it's appropriate or not to keep secrets, things like that. I don't have an exact list of what they talk about, but.
For my clients' knowledge, what does CAC stand for?
Child Advocacy Center.
Nothing further.
All right, thank you for your testimony. You may return to your seat. Any other witnesses, Ms. Thomas?
Not at this time, Your Honor. Thank you.
Okay, Ms. Dumont or Mr. McFarland, anyone you'd like us to hear from?
No, Your Honor, my client is satisfied.
No witnesses.
Thank you. All right, Mr. Hotchkiss, I'm not going to extend you the opportunity for witness testimony today, but I will allow you to make comments in closing. Let's begin, however, with Ms. Thomas.
Thank you so much, Your Honor. Again, I think that we're all very proud of Ms. DeHart. I know that we had a really rough start there at the beginning, and it's really wonderful to see her commitment to her sobriety and her case service plan, not only for the benefit of herself, but also for her child. I think that she's definitely on the right pathway to continue towards the goal of reunification. We are just asking the court for that discretion to allow for the unsupervised parenting time and to include overnights as that develops and increases throughout this next review period. As it relates to placement for the youth at this, or the minor at this time, I know that there are some concerns about what was disclosed at the maternal grandparents' house. I have full faith in our investigatory process, including the CAC interview and any outcome from that. In addition to the safeguards put in place through that safety plan, that this child will be safe while at the maternal grandparents' house. And at the beginning of this matter, we had actually requested that placement be with the paternal grandparents, and the foster care review board had denied that. And we had to go through a whole process regarding placement, and we ended up with this 50-50 setup, so to speak. And I think that it's serving the child's best interest as mom continues to work towards reunification. Again, this child is very loved and very well supported. And I hope that they continue, all of the caregivers continue to work together with Ms. Moore to flesh out some of those familial dynamics that can happen when there are, different families involved with a youth or a child. And so I believe that we have all the services in place that can help us and help this kiddo moving forward. We are asking for a standard 90-day review with that change in parenting time. And I think that's it. Thank you.
Okay, any comments today, Mr. Hotchkiss?
Yes, Your Honor. Thank you for allowing me the opportunity as well. The only comment I have is relative to placement, obviously, is that's what I'm here for. I do commend Ms. DeHart on her hard work and dedication. I'm proud of her for doing that. I know that my client has voiced to me that she's proud of her for working through this process. So I just wanted to extend my congratulations to all the things that she's been doing so far. So that is excellent to hear. Very happy for her and hope for the return of Jameson to some normalcy in life. However, as we sit here today, and again, I'm advocating on behalf of my client who is joint placement in this regard, there are some concerns. There were allegations. Again, I do agree with Ms. Thomas that the investigative process went underway and did tell us what it could tell us based on his age, but there are concerns. And I think that if we look at the file beyond the scope of what we're here for today, we're in a situation that if Ms. DeHart does everything she's supposed to do, at the end of the day, we're going to be left with an order of this court or an order of the court that says that my client has some sort of custodial relationship with Ms. DeHart. When I'm talking about placement in this regard, my concern is that the minor child has already been exposed to a large amount of trauma. And if these allegations are true or even close to true, I have a deep concern for the minor child being exposed to additional trauma throughout this process that is not Ms. DeHart's fault. I apportion none of this to Ms. DeHart herself. She did not do this. But I advocate for my client, again, the court to consider full placement being with my client, who is more than happy to effectuate parenting time with Ms. DeHart, or more than happy to work with Brene Moore, or as Mr. McFarland pointed out, perhaps a different counselor or therapist to work with Ms. DeHart so their relationship after this case closes would be a good and solid relationship. So my only argument today, Your Honor, would be for the court to consider the full placement being with my client as opposed to a joint placement, removing any sort of allegations or obstacles, again, removing any sort of trauma to this minor child and allowing this to naturally gravitate towards what it should be, which is continuing back to that court order. So that would be my advocacy, Your Honor, and I appreciate the court again for allowing me the opportunity to voice those concerns.
Thank you. Comments, Mr. Farland?
Well, we've gone through the investigative process, and I think we have a safety plan in place. My client wants it to remain 50-50. So the child knows both sides of the family, not alienated from one side. They say actions speak louder than words, and the accolades of the guardian ad litem and the worker on this case, I can't do any better than that, so I will rest.
Okay, Ms. Dumont?
Your Honor, just with regards to the counseling between paternal grandmother and mother, I think the way that this case is progressing, it's important that these families can get along and communicate well and be the best versions of themselves for the minor child in this case, so that once this court is out of their lives, that they can continue to progress for him, so he can have relationships with everybody. But other than that, I think I would ask the court to allow the department to have the discretion, whether or not mom's parenting time is supervised, unsupervised, or the ability to do overnights.
Thank you. The court finds all interested parties are given notice for purposes of today's review hearing as well as permanency planning hearing. The goal of reunification is appropriate given mother's stability and recovery, which is good to see, good to hear. The court's findings essentially remain the same. We're looking for Ms. DeHart to show us a sustained period of recovery, stabilization, housing, employment, sobriety, beyond simply the threat of probation violations as well. So it is in light of the history of the case, both current and past, that the court looks at maintaining jurisdiction probably for at least another couple of reviews. I'd like to see Ms. DeHart continue to be sober and successful, even past the period of probation. And I say that in light of the fact that this child has significant relationships with both sides of the family, because we've had, unfortunately, periods of time in the past where he's had to rely on them as primary caretakers. That being said, his relationship appears to be, as was articulated by the court initially, significantly bonded. He appears to be significantly bonded with both sets of grandparents. The court's joint order for visitation will remain in full force and effect. It's not comforting, frankly, that we have one of the grandparents advocating again not to share with the other grandparents. That does not necessarily show progress is being made by way of the family counseling. So I really hope in the next report period that we will have built better bridges moving forward. I trust the agency to investigate and determine the best way forward as it relates to the safety of the child and placement. And if there is something that comes up, I know they will bring it to my attention if placement needs to be changed. But into the immediate future, the case history remains significant in that this child is bonded to both sets of grandparents. That is reflected in Renee Moore's comments. That will be the court's order moving forward. This appears to be stabilizing. I hope the grandparents continue to try to do some bridge building because that's what's in the best interest of this child. And I will allow the expansion of visitation as requested for Ms. DeHart, as that appears to be a support for her son as well, which is the point, right? We want everything to be geared towards his success. Period. All right, I'll give you a next review date. In 90 days, it will be also a permanency planning hearing. Given the age of the case, the child has been removed since September of 2024. But as I stated before, I know we want to see a significant period of time of recovery from Ms. DeHart. The case again in 90 days. Let's see. All right, let's go just a little shy. Let's go to, I have Monday, the afternoon of the 20th of October, or Tuesday, the 21st in the morning or the afternoon. Anyone have a preference?
My client does not, Your Honor, I've asked.
Sorry, Your Honor, I was looking at my calendar trying to press unmute. I am unavailable the 21st. So the 20th would be preferable.
Are you available on the 20th at 1:30, Ms. Dumont?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
Yes, okay, very good. And Ms. Thomas, you're out the whole day, the 21st?
Yes, Your Honor.
Okay, good to know. Any other days coming up that we should look at avoiding for you?
That just happened today, but I will also be out October 16th and 17th.
Appreciate that heads up.
Yes, thank you.
The time on that, Your Honor.
1:30 p.m.
Thank you.
So for our next review and permanency planning hearing, we're scheduling that for Monday, October 20th at 1:30 p.m. I'll have the order in a few minutes. You're welcome to wait unless there's any questions.